Welcome everyone. Welcome to Victor NCA preparation classes. And this session is about professional responsibility, which is one of the core subjects for NCA preparation. And today we'll be talking about ethical lawyering. So what is ethical lawyering? Ethical lawyering here means practicing law with integrity, honesty, and fairness. Also, while practicing law, lawyers are responsible for upholding professional standards. They're required for maintaining client confidentiality, avoiding conflicts of interest, and ensuring that justice is done. So, when we talk about ethical lawyering, there are three different principles for ethical lawyering. First ethical principle is duty of loyalty. And what is duty of loyalty? So, in Model Code Rule 3.4-1, Committee number 5, it says that duty of loyalty mandates that lawyers are to prioritize their client's interest above their own and also above interest of anybody else, that is interest of others. The duty of loyalty also requires lawyers to act in their client's best interest, which mandates maintaining trust and integrity in the profession. So when we talk about duty of loyalty, there are four major sub-principles of duty of loyalty as well. So first one is to avoid conflict of interest. Model Code 3.4-1 says, avoiding conflicts of interest means that the lawyer's personal or professional interests do not interfere with their duty, which is to act solely in the best interest of their client. This also involves avoiding any situations where a lawyer's duties to one client could be compromised by their obligations to another client or by their personal interest or any relationships they might have. This is explained by one case law, which is R versus Neil. In R versus Neil, there was a law firm who represented Neil, and later on, they represented the co-accused with Neil. And this law firm's prior representation of the client, in this case, which could create conflict of interest in a new case that is involving a different client. Hence, the court emphasized that avoiding such conflicts is crucial to preserving public trust in the legal profession. Another duty of loyalty and sub-principle is duty of candor. What does duty of candor means? So according to Model Code 3.2-2, it says that duty of candor requires lawyers to be honest and transparent. This also includes providing truthful information and correcting any false statements. So these false statements can be made by mistake, they can be misunderstood by clients, and the duty of candor is to correct them as soon as possible. This we can understand by a case law, which is CN Railway versus Wallace. There was this law firm, McArcher, which represented CN Railways in the past. So now what happened? There was another set of people in this case, which was a group of farmers who were not happy with the CN Railway. And now they went to this law firm and asked this law firm to file a case against CN Railways. So this law firm, McArcher, took the case of these farmers, and this McArcher law firm filed class action against CN Railway, which is on behalf of the farmers and the representative, which was Wallace, who represented these farmers. So this happened, and this law firm didn't go to CN Railways and did not inform them that, hey, we are taking this new case which is against you, and we represented you in the past, and there could be a conflict of interest. And this CN Railway, they came to know about that their law firm, McArcher, has taken a suit against them only when they received a notice from the law firm that a suit has been filed in the courts. So the court here ruled that though there no conflict of interest, but the failure to notify That is to let CN Railways know by the McCarthy law firm that they will be taking a case against them. Led to a failure to notify, which constituted a breach of duty to disclose, or a duty to come clean, which is the duty of candor. Another some principle is overzealous advocacy. Overzealous advocacy occurs when a lawyer aggressively pursues a client's interest, and in doing so, they do it in ways that compromise legal ethics or professional conduct. This not limited to can include misrepresenting the facts or engaging in unethical behaviors to gain advantage. So in R versus Murray, they were two husband and wife, a couple who engaged in criminal activities. They raped, killed, and videotaped young girls. Now the accused told Murray, who was the lawyer in this case, as to where the tapes that they made were kept. And even after knowing that, Murray kept that confidential and did not disclose. This was considered as aggressive tactics and they were deemed unethical as they compromised the fairness of the trial. Also, that was told in the case was while strong advocacy is permissible, it must not violate professional standards or undermine the integrity of the legal process. Another principle of duty of loyalty is confidentiality. So, this duty requires lawyers to protect and not disclose any information that was shared with them by the clients, and it also ensures that clients can communicate openly with the lawyers by knowing that whatever information they're sharing with the lawyers will be kept private and secure. Not only this, also fosters trust and effective legal representation. Second duty of ethical lawyering is duty as a moral agent of justice, which means is to promote justice and not obstruct justice. And a lawyer, as a moral agent of justice, must uphold ethical standards as to promote fairness and advance justice while acting in client's best interest and contributing to the integrity of the legal system. Again, Arvid Summers Murray is also the example of duty as a moral agent of justice, as when he concealed the location of videotapes, he was not acting as a moral agent of justice and instead of promoting was obstructing justice. Third and last duty is the duty of integrity, which means having strong moral principles. The duty of integrity requires that lawyers to act honestly and consistently. This also means they avoid any deceit and maintaining truthfulness in all professional interactions. Model Code 2.1-1 says honorably and with integrity, whereas commentary number 1 says integrity is essential for a lawyer. Why? As it underpins trust in the lawyer-client relationship and the lawyer's reputation, regardless of their competence. Make sure strong moral standing is there. Example of this is Spalding versus Zimmerman. So what happened in this case that the defendant reached a settlement with the plaintiff for injuries suffered in an automobile accident. So there was an automobile accident, and after that, defendant reached a settlement with the plaintiff for all the injuries that were suffered by the plaintiff. The medical report that was provided to the defendants by the plaintiff indicated that the plaintiff might have suffered aneurysm, which is a mental disease that had not been detected by the plaintiff's own physician. So it was established, and of course, the defendants did not disclose this report to the plaintiff. So it was established that though defendant had no duty to reveal their greater knowledge of the extent of a plaintiff's injuries in context of a settlement requiring the court approval, they were still required to disclose this information to the plaintiff as this was under their duty of integrity. And it is not just duty of defending their case, it's also a duty of integrity which requires lawyers to act honestly and consistently. And in doing so, they are truthful in all their professional interactions. Hence, the established duty of integrity. So we can see here professional responsibility, ethical lawyering, which has three major principles. First is duty of loyalty, second is duty as a moral agent of justice, and third is duty of integrity. When we talk about duty of loyalty, it has further four sub-principles. First is to avoid conflict of interest, and the case law is R versus Neal. Second is duty of candor, and the case law is CN Railway versus Wallace. Third is overzealous advocacy, and the case law is R versus Murray. And fourth is confidentiality. Second duty as a moral agent of justice, and the case law is R versus Murray. And third and last is duty of integrity, which is, and the case law is R versus Spalding versus Zimmerman. So this concludes chapter ethical lawyering, and we learned so far are these principles. Thank you so much for joining me. See you again. Bye. Take care.